So once again, my name is John Carrigan with the law firm of Ross, Earle, Bonan, Ensor, and Carrigan. We are a law firm, been around since 2003, have 5 board-certified partners in condominium and land development law, and work very closely with Vesta Property Management and share a bunch of clients with Vesta Property Management, and it's always a pleasure to be back here and speak to you all again. As we go through today's presentation, we are going to talk about homeowners associations, 720, cooperative associations, Chapter 719, condominium associations. Not to bury the lead, but if you remember last year, there was probably the greatest statutory update to Chapter 720 for homeowners associations that had been in the past 20 years. This year, the legislature decided to leave homeowner associations alone. So there'll be some provisions that go in and talk about managers and management companies and how they interact with homeowners associations. But I do want you to know that the Chapter 720 was not amended this year for homeowners associations. However, a lot of changes to condominium law, a lot of changes to cooperative law. It's almost like the legislature decided this year we're going to focus back on them and make some tweaks to budgeting, meeting notice, electronic recording of meetings, all that good stuff, and we'll make our way through all of that. It is about an hour presentation today. It has been submitted to the Division for Educational Requirements. Haven't gotten the sign-off yet, but when we get done here and we hear back from the division, we'll certainly prepare the appropriate certificate. I think I emailed Kevin and all them. If you guys just keep a log of who's here today for board members and for who's online, we'll make sure we get those educational certificates to you. So let's go ahead and start out with always the fun thing, and I'm looking at all the managers in the room, changes to Chapter 468 and license CAM and what those requirements are. Important not only for the managers that may be online or in the room, but also for associations and what you should be looking for as a board member. Because don't ever forget that as a board member, you have a fiduciary obligation to oversee the vendors of the association. That includes manager, that includes the attorney, that includes the CPA, the bookkeeper, all those things. The buck stops with you, and I'm pointing to the 2 board members I have in the room, right? So important you all are aware of this. Okay, so let's take a look at online licensing requirements. So there is now online mandatory licensure accounts for all LCAMs and all management companies. You must create an account and you must maintain that online account listing the firm you work for and the associations you work for on-site managers, right? So if you're a portfolio manager, you have to list that you work for Vesta Property Management, but you don't have to list, at least unless the division changes the rules, right? This would be on-site managers. So a lot of clients on the island of the condominium, they have a full-time dedicated manager. Larger HOAs, 15, 2,000 units, something like that, they would have a dedicated full-time manager, and that would have to be listed. CAMs are required to update any changes as to the firm they're working for and the associations that they're working for, again, on-site full-time managers, within 30 days of any changes to ensure compliance. This is an obligation for the managers to ensure compliance, for the management companies to ensure compliance. And now, the DBPR, with access to the online account for the managers, has the ability to notify associations if there is a suspension or revocation of your CAMS license. That's kind of the intent, is to ensure that managers have to keep up to date, not only their registration, but any disciplinary action, and that the DBPR, by virtue of having that information, can now reach out to associations if there is a suspension or revocation. Of course, we would never run into that if we're doing a good job for our client as a manager. Professional practice standards. So LCAMs, and this is the big one, I thought it was obvious, but the legislature, we have to state in the statute, LCAMs must not knowingly perform acts that violate state or federal laws. The important word there is you cannot knowingly do it, okay? So no longer, and not that anybody in this room would go to do that, can you blindly follow, well, the board just wants to do this, right? If you come to a point where you believe that you are potentially engaging in something that is outside the bounds of what the law permits, always a great idea to mention that to the board and say, we should pick up the phone and call the attorney and have them provide a legal opinion as to whether the action we plan to take is appropriate within the bounds of Florida statutes. That creates, again, protection for the CAM. It creates protection for the board of directors, right? that the decision that they made was on the reliance of counsel, which is always a defense. In addition, LCAMs must follow milestone inspection and structural integrity reserve study directives from the board. So remember, the MERS, milestone inspection, SIR, structural integrity reserve study, and we'll use that terminology as we go throughout today. Buildings of 3 stories or more that are condominiums. They've changed the definition. There will be a slide on this later. It's of habitable units. So we're looking at habitable buildings of 3 stories or more, and we'll talk about the SIRS and MERS requirements under those. In addition, every contract that a management firm has with an association must affirm compliance with professional standards, and these standards cannot be waived or limited. So I've never seen the Vesta contract, which makes me very happy, and that's why I'm always comfortable recommending clients work with them. But some management companies were putting limitations of liability in there, right? Saying that we would only be liable up to X. That is no longer permissible under the contracts. Now, I was mentioning before we started today that one of the reasons we run into many of the statutory changes this year's is because legislators or representatives of the team that work with legislators are going to these condominium meetings, right? They're going to the cooperative meetings, the homeowner association meetings. They are receiving complaints from their constituents as to we're experiencing XYZ. You know who doesn't go to complain to the legislature? Happy HOA clients or condo clients. And so a lot of the changes, this being one of them, right, were prompted by the legislator saying, boy, I'm getting a lot of calls about failure to disclose or potential conflicts of interest that the management company didn't tell us about, right? So if there's anything to take away from this slide, and we'll dive into the details, is disclose, disclose, disclose. If your radar goes off as the manager that, oh, my brother-in-law owns this lawn care company, he does great service, I should disclose that relationship, right? If I know somebody that has a financial interest in a vendor that I'm going to recommend to the association, I should disclose that to the association in writing. If you disclose, right, there's no problem with the conflict of interest. It's where you find out after the fact that the management company had recommended somebody's brother-in-law, somebody's sister, somebody that had an investment stake in one of those vendor companies. And it's not necessarily the board, but it's the members who are unhappy with the service. And now this becomes a much bigger deal. So the walk away from this is always make sure you disclose. You're now statutorily required to do that, but it would always be something that you would want to do to ensure that your client has a full understanding of this vendor and the relationships that may exist. You're now required to disclose any activities could be reasonably seen as a conflict of interest. The question is, what does that mean? We don't have any guidance at the administrative level, right? There may not ultimately be any administrative guidance on this. So again, if your radar goes off, take the opportunity to disclose that in writing. It applies when a management firm, LCAM, or other persons with a financial interest in the above, or a relative of such person proposes to conduct the business or enter into contract with the association. So if there is anybody that's being recommended that is not written disclosure in the management contract, and there's some exceptions to that, right? Disclose the management contract, put it in writing to your board of directors, let them know. That way, when the board undertakes the vote, they know all the variables that should be considered. Again, it doesn't preclude the ability to enter into a conflict of interest, right? Relationship with the vendor. It just ensures that the association's aware. I'll get to your question. Let me get to the end of this slide. Contracts for services outside of the management and compensation, referral fees, you must also disclose. So if you're getting, not a kickback, because kickbacks are illegal, but if you're getting any type of referral fee for sending a client to a landscape company, even if it's a free lunch, disclose, disclose, disclose. Bids over $2,500 would require multiple solicitations unless the conflicts are disclosed at a board meeting agenda and on the notice. So if it's above $2,500, not only should you be putting in writing, but it should be disclosed on the membership meeting notice, or I'm sorry, the board meeting notice where the contract will be considered. And this is the consequence of it. If you fail to disclose, right, which again, nobody would ever go ahead and do it. If you fail to do it, the association can then terminate that vendor contract, and they're only liable for the reasonable value of the services provided. right? So 6 months into a landscape contract, if it's found that there was a failure to disclose the financial interest of the property manager's wife in that company, the board then has the unilateral right to go ahead and terminate that contract. They still have to pay the reasonable value of the services, maybe the contract price, but they're not bound for 3 or 4 years for that particular contract. Did you have a question on this particular one? Go ahead. There is not. I don't know if Vesta has developed one to put forward that is a uniform process to go ahead and do that. But at a minimum, it should be in some form of writing, and that should be saved both in the association's official records and Vesta's management records. So if any member ever comes up and says, look at this, I see a conflict of interest, you can say, wait, the statute requires us to disclose it. And here's copies of the email. Here's copies of the form that's required, right? If Vesta implements forms for its management companies. A lot of times what you'll find is these management companies, to the extent they have an interest in a company or a vendor that may be utilized, right? They will disclose that in the management contract, right? That we have a relationship with this entity, and to the extent you hire them, we're telling you that there is a relationship there. There's a financial interest there, right? And again, that would satisfy the requirement. But if you consider that at a board meeting, my recommendation is, I know it's in the management contract, make sure you disclose it again in the media agenda. Good question. Okay. Any questions from the managers in the room? And again, online, we'll go ahead and just put it in the chat and I'll address them. But anything about amendments to Chapter 468, if you do what you've always been doing, right? The good news is, I don't think anything changes for you as far as this, other than the online registration, right? There's a little bit more work there, especially if you're an on-site manager. But when I saw these changes, they basically formalize what I've always viewed as best practices and been my experience with your management company. And so I don't view this other than making sure we disclose, right, any substantive changes in the way you would practice. Okay. Sure.
For on-site managers, is it full-time on-site managers, or does it apply if they work 15 hours a week?
So it's undefined. It says an on-site manager. So my recommendation is that if you're on site, and I think that's different from a portfolio manager where I have 2 hours for this one. But again, my recommendation is we're going to wait for DBPR guidance. And unfortunately, these laws went into effect July 1st. It takes some time to go through the administrative process. So we will certainly continue to update our clients, update the managers if there is guidance issued that farther clarifies that. And that's what the administrative process is for. That's certainly something that we would provide to all of you, right? But again, better to put it on there and overshare with the DBPR than to run to something. Because I think, as you all know, you hold a licensure, I hold a bar license, right? It's not usually the client you're working with. It's the aggrieved homeowner that has a personal vendetta, right? And so we always need to engage in best practices, but ensure we're meeting the minimum requirements required by statute. Good question.
John, you mentioned bids over $2,500. Could you?
Sure. Sure. So this isn't the competitive bidding requirement, right? This is different. Let me jump back to it so I can pull it up. It's getting there. One more. Again, so bids over $2,500 where there is a disclosed conflict of interest, you have to obtain multiple bids, right? So in the condominium statute, you're talking about that threshold, that 3% requirement that requires multiple bids. This is an additional requirement that would necessitate a lower threshold, right? And the idea is that you've disclosed it, but you've not only disclosed it, but given the material value of the contract, you've also obtained competitive bidding requirements. Really good question. Really good question. Okay, let's shift over to condominium and cooperative requirements. As I go through these, we will certainly go ahead and talk about the applicable statutory provisions. I do want you to know that even though this is all in the same section, if the citation in the slide references 718 and 719, that means I'm talking about both condominiums and cooperative clients. If it only mentions 718, it's only going to be the condominium. Because why would the legislature make everything the same in both of them and make our job easy, right? That would run me out of a job, and I need job security, I guess. I really don't know. But of course, you'll see in here, I think every change to the cooperative statute is parallel in the condominium statute, but it is not vice versa as we go through all of this. Okay, so let's talk about termination rights. So, and I'm now going to look at the board of directors, right? Before you go under contract with a management firm, you now have a fiduciary obligation to ensure that that CAM is licensed and that management company is properly licensed. It's not hard. You go on the DBPR website, but you are affirmatively required to go now verify that. So make sure that as a board member, you just understand. If you're working with legal counsel, one of the things I always do, right, is a new management firm comes in, who's your manager, right? And then we just go on the DBPR website, we look up the licensure, we print it out, we put it in the file, we give you a copy, and then nobody can ever question that you did your due diligence at that point in time. But a board is now required to do that. A failure to do that could give rise to a breach of fiduciary duty. Now, if the CAM license is suspended or revoked, the statute now permits the association to immediately terminate upon written notice to the manager or management company. So you're no longer bound by a contract where the CAM cannot perform the services provided. And the intent of this is really to protect the association and for accountability, both for the board to the members and for the board in its relationship with the management company. So important, gives the board the ability, again, to get out of a contract. They're not bound for 2 or 3 years if the CAM or the firm can no longer provide those requirements. Now, insurance appraisal requirements. This one's only going to be applicable to condominiums. And so there's some really important changes when you talk about insurance requirements required for your condominium association. The amount, and this is the change, of adequate insurance is required for the full insurable value, replacement cost, which is what most clients go ahead and bid their condominium insurance out on, or similar coverage must be based on replacement cost of the property to be insured as determined by an independent insurance appraiser or upon update of a previous appraisal. And that should be done every 3 years. So every 3 years, you should be getting an independent appraisal of the association property or having the prior one updated if you're working with the same firm. And 2, my recommendation is do it based on the full replacement cost. There is now some wiggle room within the statute where it says may, because you've had some condominiums, especially ones on the beach, where they've had a real hard time obtaining insurance and ultimately end up with Citizens, the insurance company of last resort. Not to say anything about Citizens, but they are truly they will only insure you if nobody else will. So that's why there's some wiggle room on replacement value. But if you can obtain it, that's the type of insurance the association should always be having in place. And of course, a copy of the appraisal, ensuring compliance with the 3-year requirement, always part of the association's official records. Now, the appraisal must be conducted independently to ensure an unbiased and accurate replacement cost assessment. So make sure that you're hiring a third-party vendor to come out and do that. I'm sure that the managers in the room can certainly make recommendations as to who those would be. You can certainly talk to your insurance broker and they could provide a recommendation. But this is you either do it or you're in breach of the statute kind of situation. So just something to be on your radar. And obviously, the entire point of this, of requiring a replacement cost analysis required every 3 years, is to ensure that in the event of a peril, we've been lucky, knock on wood, right? We haven't had a lot of hurricanes come on the East Coast, but the West Coast, much different. But fires and other things, that the association's not left in a situation where it's an outdated appraisal. The value of the insurance policy is insufficient to undertake the repairs, resulting in a delay to the repairs because there may be a lack of funding to undertake the repairs. The adequate assurance is there. We have the money. Now we just got to hire the contractor and get it done. If we don't have the appropriate amount of insurance in place, we don't have the money, we can't hire the contractor, we have to levy a special assessment or go get a loan, delay. And the entire purpose is to get the unit affected or units affected back up and running, getting people back in their homes. Okay, this one is 718 and 719. Official records in digital access, okay? So associations are required to maintain official records, including meeting minutes, and we'll talk more about this, recordings of board meetings, committee meetings, annual meetings held by an electronic video conferencing platform, right, in the association's official records for at least 1 year. What does that mean? That means that if you are having board meetings, probably the most usual, via Zoom, via Microsoft Teams, via WebEx, whatever the video platform is, you now have to have the ability to press record, and you have to record the meeting, okay? Then you have to take that recorded meeting, and you have to retain that video for 1 year, okay? And there's going to be another slide. You have to post it to the website if you're over 150 units, and as of January 1st of 2026, if you're over 25 units, if you're a condominium or cooperative, okay? That's a big onerous on our associations. Now, the intent is obviously, one, it's not that hard to press the record button, but there are some financial impacts that where do we store this? Who maintains it? Who monitors that it's 1 year, right? So these are all considerations that you're going to have. In addition, the statute has always contemplated that if a board member cannot be there physically in person, that board member has the right to phone into the board meeting, okay? Which is you take out your iPhone if you got a speakerphone and they call into the board meeting. Only board members have the right to phone into meetings, right? You can certainly open a conference call line to all members, but you only have to do it to a board member. However, what we've seen post-COVID is a lot of board members would prefer Zoom, right? It's easier. You can do it on your phone, your iPad. Everybody knows how to really operate that platform. Not to proffer Zoom. I mean, there's a bunch of video conferencing platforms, but it's not hard to do. But if you allow a board member to appear via Zoom because they cannot be there physically in person, you now are required to make that Zoom available to all of your members. And so on the one hand, I get it. The intent of the legislature says it's not that hard to press record. There's going to be some additional expenses with storing the stuff and logistics of ensuring it's available and on the website and all of that. But it's not too much of an onerous for an association to go ahead and handle. On the other hand, I can see a lot of clients who have migrated to the video conferencing platforms saying, we're not sure we can meet all those requirements, right? And so it may have the opposite effect of discouraging some condominium cooperative clients from making Zoom available to its members. It may have actually, I think, the opposite effect of probably what the legislature intended. I found, and I'm not young, but I'm in that age where I kind of grew up on video conferencing platforms, that for me, it's not hard to press record. It's not hard to find a database to store that. It's not hard to put it on the website. But those are all considerations that the board member should really be looking at. Do we have the feasibility to do it? And if I'm a smart board member, I'm looking to my managers and saying, y'all are going to take care of this, right? At a reasonable fee, right? Which they're entitled to go ahead and do because there's going to be a cost to them to go ahead and undertake the work and store it or utilize a platform and the cost thereof. But if I'm a board member and I'm not savvy in the technology, my preference would be, let's make Zoom available. It opens the door to transparency. It makes it easier for board members to attend, for members to attend. Remember on Zoom, if you're the DJ, right? Like you can press mute and mute everyone, right? So that I really like that ability to do it. I don't think that transparency and accessibility, right, are outweighed by, oh, now we have to press record and store it, right, and put it on the website if we're over a certain size. So I don't see that shift, but I can certainly see some associations that would be concerned about that. Now, in addition to the video conferencing platform and those requirements, remember too that when we're talking about that, that's going to be, you got to provide in your board meeting notice, like the link, right? The meeting ID, the passcode, and I know on Zoom, I think Microsoft Teams does this too, there's always the ability to phone in for audio only. And so I know on those platforms, when you create the meeting, you can copy and paste that. And that would be something of copy and paste it and post it on the board meeting agenda that's posted, certainly. And if, as a courtesy, you email it out to members, which a lot of clients do, or they'll post to the website, it would be there for them to go ahead and access it. Okay, So there's that, video conferencing platforms, that requirement. In addition, there's always been some ambiguity as to what constitutes financial records under the official record statute, right? They have now clarified that that includes bank statements and ledgers are part of the financial records of the association. So if a homeowner comes in and says, I want to look and make an official records request for access to the association's financial records, obviously you would have the year-end audit or compiled financial statements. You would have the monthly cash flow statements from the property management company, the balance sheets, other financial documentation. But in addition, bank statements and association ledgers, right? Whether that's the general ledger, right, or a sub-ledger off that general ledger, homeowner ledgers, right? Anything that deals with the financial bookkeeping of the association is realistically now in play for that. I've never run into an issue where I've had an association say, well, we don't want them to see our bank statements, right? But understand that that's now required if you had taken a different position. Now, associations that are 100 or 50 more units must publish key documents on the website. So you have all these documents that are official records, but if you're over 150 units, you have to post a copy of the declaration, bylaws, articles, rules and regulations, board meeting minutes for the past 12 months, and video conferencing recordings to the association website or mobile app. And remember, when you're dealing with that website or mobile app, it should be password protected. So it's not John Carrigan can't log on, right, and go see the business of the association. But every homeowner should have a unique login and ability to access that, or a general one that is shared with the members to go ahead and do that. Now, why is this important, right? Transparency and accessibility. We talked about why the legislature undertakes these changes. It's because they went to these board meetings where people complained of these things, and they want to force associations to be more transparent, to make it easier for homeowners to access the essential documents of the association. Now, on the online document availability portion that says if you're over 150 units, January 1st of 2026, that's reduced down to if you're over 25 units. So just be aware of that most condominiums other than the small ones, right, are going to be required to do all these things. And I would start implementing those procedures now to get those in place and ensure the website or mobile app is live by that time. Okay, so key considerations to walk away from, why this was done, right? It will necessitate associations to consider how they conduct meetings. We talked about that, right? Whether we make that platform available to members and incur the burden, right? Or require a management company to incur the burden, right? Of maintaining those types of things. It's 12 months. I know Zoom provides a cloud-based system, right? That probably could be linked into your website where the people can just go and Zoom really hosts everything and keeps everything for that year. You need to give consideration to the cost and what additional administrative financial costs there's going to be to the association if you do allow Zoom to go ahead and be in place, right? And lastly, and most importantly, there had been this area of ambiguity post-COVID where it was, do we have to have a physical location if we have a virtual platform where everybody can come? The statute has now been clarified. Yes. You are always going to have a physical location for any board meeting or membership meeting of the association. There is no more, the entire thing's virtual. Okay, so the statute now requires that, no ifs, ands, or buts about it. Now, every board member at the board meeting could appear virtually, theoretically, but the property manager still have to be sitting in a room like this, right? And just waiting to see if anybody shows up or on site at the clubhouse or wherever it may be, but you're always going to have a physical location. Your meeting notice is always going to indicate the location that it is at. All right, let's jump into financial reporting and investments. What can a condominium association do with the money it collects from the homeowners? So this is going to apply to both condominiums and cooperatives. So a couple things. These are some happy things. I think the CPA lobbyists really went ahead and pushed this first one. So it used to be that within 120 days of the end of your fiscal year, which for most associations is going to be December 31st of the prior year, you had to have your audit completed, your compiled financial reports, your reviewed financial reports, that year end, here's where the money went, right? Well, 120 days after the end of the year is tax season. And every CPA is running around trying to get that stuff done to keep them clients out of IRS jail. And you're calling them saying, hey, can we really go to get that done? Right? Well, they came in, they've now extended that to 180 days. So realistically, and I'm going to do my math, that's like June, right? About the end of June, when that is now going to be done. So the CPAs, please don't harass them, but April 16th, 17th, the day after tax day, call and get on the list, right? Where are we? What do you need to go ahead and get this done? Remember, though, that it's 180 days after the end of your fiscal year, unless your bylaws provide otherwise, right? So some associations give more time, right? But it's at least going to be 180 days after the end of the fiscal year. Now, your year-end financial reports, whether it's an audit, compiled financial statements, must be delivered within 21 days of completion, meaning you have to notify owners that it's done, okay? And that a copy for free is available on request, and that if they submit a request, they get it within 5 days. Given how easy it is to go ahead and post this kind of information on the password-restricted website, most clients are sending out e-blasts, right, stating it's on the website, it's been posted, right? And now everybody has access as needed. However, if you don't have it on the website and you don't maintain a website, right, you have to provide actual notice to your unit owners, and you have 5 days if they say, I would like a copy of it, right? Obviously, if you send it to them, right, everybody just gets a copy of it. You've satisfied the requirement, but you're only required to provide notice that it is finished and it's available upon request. Importantly now, in addition to all this, the association must now document compliance with an affidavit signed by an officer or a director, not the property manager. Property managers shouldn't be signing affidavits for the association, that they've complied with the notice requirement to owners. So financial report gets done June 15th of 2025, right? Or I guess 2026 will go into next year. We notify owners within 21 days it's available or been posted to the website. An officer of the corporation or a member of the board of directors should be signing an affidavit that that's been complied with. Have your manager prepared or have your legal counsel prepare it to ensure it meets the requirements of an affidavit, right? But the board member needs to actually go and execute that, and then a copy of that is put into the association's official records. From my perspective, I think this is a great thing, because when somebody accuses my client of not following the statute and I have an affidavit, it's kind of case closed. Yeah.
But that says within 21 days. What if you do it prior to? I have always used my budget, sent out the financial report, letting you know that it'll be available. So you can do it early.
Correct.
Okay.
Correct. So the deadline is 21 days, right? But even so, obviously the report would have to be finished, right? But if you get it from the auditor and then you put it on the website that afternoon, sign the affidavit and we're done, right? Okay, let's talk about investment of association funds. So especially in the wake of the past couple of years, we've had really high inflation. And in addition, the shift in the condominium and cooperative statute to where the association is going to require actual reserves be put in a bank account, right? Not in the homeowner's pocket where they can invest it themselves, but in the association's bank account. There's been a lot of question of what can an association do with the reserve funds it's collected. And if you talk about a condominium of reasonable size, I mean, that could be hundreds, if not millions of dollars that they have in reserves. That's a lot of money that you want to outpace inflation in this marketplace. So one, this section has been added that requires the board of directors to use, quote unquote, its best efforts to make prudent investment decisions, balancing the risk and return of association funds. So now, board members, you are imposed with this obligation to use your best efforts to find where to invest the association's money. However, the board is limited in what it can invest, at least now under the statute. So the board can invest reserve funds in certificates of deposit or depository accounts in a community bank, savings bank, commercial bank, savings and loan association, or credit unit without needing unit owner approval. Here's the question we've been getting. Well, we put our money with Merrill Lynch, like in a mutual fund, which is reasonably safe. We invest our money with a financial advisor who put us in bonds. we've invested money in T-bills, right? With the federal government, right? Which is AAA rated, or I guess AA rated now, right? And that's always been considered at least for that one, a very sound and reliable investment, because if that goes down, we're all going down, right? And it doesn't really matter. However, the statute is now, I interpret it that without a membership vote, you're now limited to only these options. So most clients put it in a CD or some sort of money market account that is clearly recognized by this. But those other investment options, by virtue of passage of the statute, are really put into question. We are waiting for division guidance to say, well, are these other ones acceptable? But by the plain language of the statute, the answer appears to be no. So what I do recommend, and certainly if we work with you, let's make a phone call and talk about the risks, right, and the reward. Because you're certainly on a CD, you're going to get an okay rate these days, but you're not going to get what was 2 years ago a T-bill at 6%, right? That was somewhat outpacing inflation. But under the statutory changes, you're really supposed to be in CDs or other depository accounts and nothing else.
Because the other song have I see the shirt.
Well, that's the other thing, right? So there's some question out there. What I've been recommending to clients is obviously follow the statute, and you can't be in danger, right? So I've been telling clients, put in a CD, put in a money market account, or other equivalent investment as what is now permitted by statute. Anything beyond that, you run the risk that you are no longer following the statute. That is a breach of fiduciary duty. However, I'm not a financial guy. I have a financial guy. I throw him money every month and he puts it away. And at some point I'm allowed to retire, I'm told. I have clients that are very savvy investors, and they get on the board of directors and they say, we will never outpace inflation. And we are supposed to be using our best efforts to help the members, right? In this $1 million in reserves we have until we have to use it. So there is some tension that the legislature may have created unintentionally about what can be done. My recommendation to you is CDs or other depository accounts. And anything beyond that, you should really be talking to legal counsel to go ahead and understand what it is. I am not recommending clients put it into T-bills, mutual funds, or anything else, because the statute, in my opinion, does not allow it. Do you have a question?
Right, it says, without unit holder approval
Right.
at the annual meeting, but you have the unit holders approve investing in mutual fund.
That's the question, right? Why does that language exist, and how does that it be interpreted in the statute? So I haven't had that issue come up with a client yet. As far as I guess we're going to annual meeting season, so we'll find out, right? But there would have to be a lot of disclosure on that front. But I do believe that there is perhaps a contemplation that other investment strategies could be used, especially if a majority of the membership approves it. Good question. Okay, so again, financial flexibility weighed against association fiduciary duty. And as a board member, you know that 99% of the people love you, but there's always that one or two, right? I mean, it's just the nature of the beast. It's the same with the attorney. It's the same with the property manager, right? You can't make everyone happy. And so I think you have to weigh it all. Again, the conservative risk adverse is CDs or other depository accounts. And beyond that, again, is with membership approval. If you know, it's a sound and financial investment. Okay, let's move on to meetings and voting procedures. So we talked about video conferencing, right? Importantly, and I want to impress upon you, this applies to board meetings, unit owner meetings or membership meetings, and committee meetings. So you have an ARC, right, in a condominium or cooperative, and you do make it available, right, via video conferencing platform, you are going to have to maintain the requirement of that recording for a year. You have to go ahead and on the meeting notice state the hyperlink, the phone numbers, as well as the physical location. So you're going to have a Zoom or Microsoft Teams information, and it's at the association clubhouse at this address on the meeting notices. You're going to go ahead and keep those for 1 year. Now, the statute requires you to keep board meeting minutes forever, right? So you're going to have your board meeting minutes forever. You're going to have video of the board meeting, which those meeting minutes reflect, for a year. Certainly you can keep it longer than a year, but at a minimum, they have to be there on a year. And the division now has jurisdiction to ensure compliance with that. Annual meetings. So a little bit of a tweak to 718.112 in the annual meeting when there's video conferencing. I'm going to walk you through some scenarios that I see, but it is hypotheticals until we get to December, January, February, and I guess we'll find out how it plays out, and hopefully the division has given us some recommendations by then. So annual meetings, one, it used to be that you had to have your annual meeting within 45 miles of the physical location of the condominium or cooperative association. That has been reduced to either 15 miles or within the same county, right? So just understand that if your community's in Melbourne, but you want to have it at this Vesta office, right? Your bylaws need to allow it because you're not in the same county, you're not within 15 miles. So just think about that. It may create some hurdles for associations, but the idea is, right, that you can't have the meeting in Anchorage, Alaska, so the people can't attend, right? Or the French Riviera or whatever. Now they could appear via Zoom, right? But it needs to be within 15 miles or the same county. And this is the interesting part, if conducted via video conference. So for the unit owner meeting, we're going to make Zoom available, which is, I think, is a good best practice. We're going to record it. We're going to do all the things about storing that, but we're going to make Zoom available so we can increase membership participation, right? The statute now says a quorum of the board of directors must be physically present at the location where the unit owners are going to come attend. So let's assume, for the sake of a condominium association, that we're going to have the association's annual meeting right here at Vesta Property Management, right? We're within 15 miles or within the same county. It's been properly noticed, right? Via Zoom and the physical location being here, okay? What happens if a majority of the board of directors aren't running again? And they're like, I'm in the French Riviera. I'm in New York. What do you do? I mean, that's really the question. I get if everybody's running again, right? They have an incentive to be there and give their stump speech if that's part of the agenda. But many a times I have an outgoing board, right, that's been there for a while, and there's new blood coming in for whatever reason, right? They're retiring, they're tired of it, whatever it may be. The statute says that apparently we have to go pick them up in a black unmarked van and kidnap them and bring them to Vesta Property Management, right? So that we meet the statutory requirement. So I can see some troubles. Again, this is me. I'm always worst case scenario guy, right? How would I deal with that, right? This keeps me up at night, but we'll find out as we go through the year how this is going to play out. I would imagine for most associations, I get a high level of the board members participating and a high level of the board members being physically present, but there are going to be some scenarios. Now, there's no penalty in the statute if you can't get a quorum of the board to be physically present at the location, right? It doesn't, there's nothing that says it invalidates the annual meeting or the election. I don't think that's the intent. But this is an area where the divisions are hopefully really going to step in and say, well, you have to make your best efforts, right? Or if this doesn't occur, it doesn't invalidate the election. Because I can certainly see the person that gets 6th place on people running for 5 seats challenging and say, there was a component of the statute not met. Again, unintended. I get why they wanted to have that at the legislature, right? But there may be some outcomes that we need to go and think about. Hopefully for none of you, either online or sitting in this room, that we run at that scenario. If we believe that's going to be a problem, pick up the phone and call council. You may want to do a little bit of a straw poll with your board of directors, the existing one going into the annual meeting. Y'all going to be there, or at least 3 of the 5 or 4 of the 7, right? And let them know that there is a statutory requirement that they go to be there in person. Okay. Now, electronic voting. So for the people in the room, do either of your communities use electronic voting? No? No? Okay. Okay. So there is a real push to come into the 21st century from the legislature and make this available. And when the statute first came into effect, 718.128, again, only condominium associations for this slide, although there is e-voting in the HOA statute and the cooperative statute, but the changes here, only condominiums, right? Is it should not be burdensome to cast your vote in an election at the annual meeting or an amendment, right? We should make that as easy as possible. Meaning if you're sitting there watching Sunday night football right? And you get an email from the vendor for the upcoming annual meeting, I should be able to get on my smartphone, pop in my information and say, I want to vote for John Doe, Jane Doe, and John Carrigan, right? For the board of directors. It should be that easy. And so for years, we've now had this process under 128 sub 1 through 6 that said that if the board had a board meeting and adopted e-voting and implemented the procedures of the e-voting, right, that can now be done. The legislature has now kind of forced the hand to really push or incentivize associations to engage in e-voting. So number one, previously the statute said that if the board wanted to implement e-voting, you had to have a board meeting, you had to give 14 days notice, like when you do a special assessment or rule change of the board meeting, and the board would have to adopt a resolution implementing e-voting. Now, no more 14-day notice to members. The board, upon 48 hours posted notice at the association at a regular board meeting, can say, we're adopting e-voting in accordance with 718, 128, sub 1 through 6. Okay, so the 14-day notice requirement is gone. I think that makes it easier, right, for the board to make a smart decision on that. It also now gives the members, upon 25% of the total voting interest, to petition the board to force the association to adopt e-voting, right? So if 25% of the membership signs a petition, name, unit number, signature, and the board receives that, right? The board within 21 days must have a board meeting and must adopt electronic voting in accordance with the statute. You can't have the board meeting and say no. You have to go ahead and do it. Now, importantly, that petition has to be received by the association within 180 days of the prior election. Why is that important? Because I would imagine if they didn't have that in there, 2 weeks before every upcoming annual meeting, you'd get the petition. And you'd be running around. We got to find an e-voting. We got to renotice. No, right? So realistically, I guess it depends when your vote was last year. But if your vote was, I guess, before March of 2025, we're approaching the 180-day mark, right? And so unless you've gotten a petition as of, I guess, the end of September, you know you're not going to have to worry about this forced conversion to e-voting for 2026. But I imagine as more people become aware, and certainly people online are now aware, right, that this is a statutory right of the members, right, that we will see more of a push of clients implementing e-voting. Now, importantly, this does not change the fact that the electronic voting remains an opt-in system, right? Meaning that you can't force owners to e-vote. You have to say the board has adopted the procedures, either because we adopted it as the board, or in the alternative, we received the petition. Here's the form to sign up. And you can only utilize e-voting for that unit owner if they've signed the opt-in form. And once they've opted in, they're opt-in for every single time thereafter until they opt out. But they still have to consent in. And so what we're finding with a lot of associations is you're dealing with a hybrid approach to any annual meeting, any membership meeting, where hopefully a majority of the members are utilizing the electronic voting, right? Because they have opted into it. But you're always going to have some residual people that would prefer to get it in the mail, or old school like me, I want to show up and socialize, right? And cast my vote in person to make sure it counts, right? So that's the system is not changing. It's just that e-voting is now easier to implement. Okay.
If someone opts to e-vote, can they, at their option, do a paper ballot instead, or once they're in e-voting, are they in that forever?
No, so they can still, as long as they haven't already e-voted, right? Then you can come and cast a paper ballot or turn in a limited proxy. Absolutely. You can't do both. It's not Chicago, right? Nothing against Chicago, but like, that's famous for ballot stuffing, right? Yeah, like they have the right to attend. They have the right to utilize the other options. But the point being is when you opt into e-voting, you're opting in, at least the form we give to clients, to electronic notices of membership meetings and board meetings, meaning that you're not going to get the limited proxy in the mail or the mailing. Still means you can come down the elevator if you haven't e-voted, right, and ask for a paper ballot, right? Or you can walk in and say, I'm going to get my phone out and do it right here and cast it, right? But again, there's always the alternative options. It's just that they won't get the physical mailing, right, until they go ahead and opt out. Okay. Now, this is the portion that we're really looking to the division to come up with some clarification, because there's now a new subsection for condominiums only under 718.128 sub 7, right? That says that if you have not adopted e-voting, right, you have to create a general email address by which owners can submit their own electronic ballot, right? Meaning, I guess, a form that they would go and fill out and attach to an email and send in, right? So if you don't have e-voting, you have to now create this other option. So no matter what, when you walk away from today, we're either having formal e-voting under subsections 1 through 6, right? In that opt-in form and all that, or we're creating an email address where owners can submit their own electronic ballot. Condominiums only, okay? Now, what does that consist of? What is an electronic ballot? Well, I could tell you what the statute says, but I think in practicality, there's a lot of details missing on how it is. So one, you have to create the general email address, right? So abccondominium@gmail.com, or Vesta provides an email address, okay? And any owner up to the time the ballot is called can send their electronic vote in through that email address. So practically what that means is the property manager needs to have their iPhone out, or their iPad, or their computer, or a board member at the meeting, and you need to be pressing refresh on that inbox to see if anybody at the last minute submitted, right, an electronic ballot. And
The turbo stand and
correct, exactly. Now, here's the thing. Let's assume you get something at 6:59 and the ballot's being called at 7 p.m., right? The property manager checks. That e-ballot has to have certain information on it. Much like a limited proxy is required to have certain information, it has to have all these items, right? So it has to have the unit number. It has to have the owner's first and last name, which if they put that in there, that's considered their electronic signature, right? You don't actually have to have a physical signature. That's their electronic signature. And it has to have this waiver notice, right? Which says the waiving the secrecy of your ballot is your choice, and you do not have to waive the secrecy of the ballot. So what I can see a lot of is, right, I get an owner filling out a piece of paper, writing their name and the unit number. I don't think any unit owner is going to understand that you have to put this disclaimer in, right? And so unless the association is affirmatively sending out these ballots to people to go ahead and fill out, essentially a unit owner, maybe the division will come out with a form that a unit owner could use that would make it a little bit easier. But I could see a lot of people submitting their electronic ballot under sub 7 that has everything but the disclaimer. In my opinion, is going to be it does not meet the requirements to force the association to count it. So I guess fortunately or maybe unfortunately for me, I'm going to recommend to a lot of clients that you probably have me at the annual meeting, right? Because somebody's going to have to be the referee on these, right? And the managers, y'all are busy enough checking people in, making sure the board feels that they're loved, right? Saying hi to members and making sure that they feel that you're, interacting with them. They don't have time, right, to sit there and I guess maybe refresh the inbox. But then if 5 come in at the last minute, we're looking at them going, does this meet all the requirements, right? And so a lot of times the associations will have legal counsel there to say, look, your job is to be the referee. When these come in, you look at them, you make the legal determination, do they meet the statutory requirement? If they do, we count them. If they don't, you write disregarded, right? So if it's kept as part of the official records, we disregard it and you sign it, John, right? And you put the date, right? So now if anybody ever challenges the election, you made the call on your part, right? So how can this confusing area be avoided? You could implement electronic voting. I think that's kind of the incentive of the legislature is maybe just do what we've tried to encourage you to do, because otherwise you're going to have this general email and you're going to have to make these game time decisions and all that stuff. So something to think about. Sub 7, I think there's going to be some divisional rules. I'm hopeful that there will be that provide some guidance on that. But it will certainly be a testing ground as we go through the next couple months for annual meetings. Again, condominiums only. So HOAs, no. Cooperatives, no. Questions? No? Okay. All right. Budget and funding of reserves. Do you have a question? No?
Yeah, I do kind of.
Okay.
It's so vague. And
Go ahead.
we do a mailing.
Mhm.
And we're gonna send out a limited proxy, possibly a ballot in the old enclosed envelope
Yep.
inside the envelope.
Yep.
We're gonna have to make that formal,
No.
Included in the first, how do we do that?
No, I don't think my recommendation is that like the association essentially not worry about this, right? If you don't have electronic balloting, do what you've always done, which is the mailing with the membership meeting notice or the annual meeting notice, a copy of the agenda, the limited proxy, and the double secret envelope for casting a ballot, right? What I'm trying to make associations aware of is the obligation to create this general email address and the obligation to press refresh on the inbox to see if something comes in that meets this criteria, right? If something comes in that meets this criteria, we need to count it, but I'm going to guess a lot of times it's not.
So we didn't create some homeowner.
Correct. Much like a limited proxy, a homeowner could make their own limited proxy, and I, as the attorney, am sitting at the meeting going, well, this isn't our proxy, but if it has the date, the time, location, the signature, the unit number, we have to count it, right? So this is one of those things that my guess is the division will likely create like a form that somebody could go on and utilize to go ahead and cast an electronic ballot. I really think this is an incentive to say that because this creates an area of additional work and murkiness, that really if you just do online voting, because remember, if you do sub 1 through 6, which is the standard one where you use a third-party vendor, right? You don't have to have this, right? And so I think it's a push to get you to go ahead and do that. But again, it exists. If you create the email address, and I think what you'll find is most people don't even know about this or won't use it. So you press refresh, nope, nothing came in. Let's turn back to the proxies and the votes that came in. But really, really good question. Yeah, it's gonna be a fun time in annual meetings figuring this all out live. Yes. Well, I would certainly, if you don't have online voting, right, let people know through an e-blast that this is the general email address, but you don't have to say it's for electronic proxies, right? A lot of associations have that, like, instead of the property manager coming in at 8 a.m. and opening their inbox to 500 complaints, right, from various associations, they have a general email address that says, look, if there's a sidewalk that's cracking or there's a leak somewhere or something like that, send it to the email address. And I don't know if the property manager or the board manages that, but that is sufficient, right? If they send it to that email address, that's what has to be refreshed, and that's what you have to look for the electronic ballots.
So we just simply say we're gonna use email X, Y, and Z for electronic voting. We let them know.
Correct. Or we're going to use it for all association business. Correct. Exactly.
Property notice for the hours at which they agree that they will adapt.
Yep.
That's the only notice decision. You don't need to send something else.
Well, so to meet their criteria to adopt e-voting, the answer is no. But practically yes, because once the board adopts e-voting, right, then you have to have people opt in. So there is going to be some outbound communication to members with a lot of them. And I mean, there's HOA Vote Now. There's a bunch of other ones that are really good vendors and very reputable. And I'm certainly, Vesta's probably has knowledge of clients that have utilized them. Usually that vendor has an opt-in form. If not, we certainly have provided clients with opt-in forms, but that person has to opt in and we keep that in their unit file, right? And then the e-vendor, essentially, we give the meeting notice, the agenda, the limited proxy, whatever is the criteria that we mail to members, we give it to the e-voting vendor, and they're responsible for implementing the communication to the homeowners of all that.
We're getting closer to
Yep.
Or we're gonna have the meeting where we let that. If we want to be. So since if I had to do, I guess special notices with time frames, we're gonna eat into that 60 days.
Correct.
Would be my concern. So
Correct.
I'm just thinking from a practical sense. What tends to do this year.
Yeah. Right. So the question is from a perspective of timing coming into annual meeting season, is there enough time to do it? So certainly if we act now, right? I mean, if my annual meeting was in November, I would be concerned, And I would talk to the e-voting vendor, like, what's the time to ramp up and get your notices out and get your database set up for your homeowners, right? And I think that conversation needs to have, but I would like to have e-voting in place before the first notice goes out, the 60 days, or it be done right around the same time. Because again, once you get within 30 or 45 days, you may be able to send out the opt-in forms, but how many of them you're going to get back? And then all of that data has to then be put in a database with the e-vendor. And if they take 3 weeks or 2 weeks to do that, you're not going to have enough time, right? I'd like to work out all the bugs. So I would say that if your annual meeting is in January, February, March, I would feel very comfortable right now that go find out the pricing, right? And figure this out and figure out whether it's something the board wants to do, right? And implement. And again, if you do it at a board meeting, get with your legal counsel because there's a specific resolution. It's a template, but like it's a resolution that we recommend you put into place, right? That outlines everything. But I think there's enough time. I think that if you're prior to the end of the year, the clock is ticking and you would need to act very quickly. If your board meeting is not till the end of October and you're having your annual meeting before the end of the year, that's a really, really tight timeline. And I would hate to be caught in the middle of trying to implement the system and try to conduct an annual meeting, right? Where, you haven't done all of it. So I think it's something out there that you should be talking to your boards about. And I think from a timing perspective, if you're 60 to 90 days out, I think it's very feasible. If you're less than that, it's going to be hard to implement and ensure that you're live and it's functional and we understand what's going to be done in that time frame. Really good question. You say that because you don't want to have to worry about budgets and reserves, though. Okay, so does anybody need any coffee before we get started? No. Sure.
My meeting start, get ready to start, and how do I check for it? See if I have more balance.
Well, the association's obligation is to check at the time the vote is called. Okay, because the statute doesn't say you can cut it off 5 p.m. or whatever.
Right, but like the other night, I went, no internet, and
You're then and if somebody casts an Evo, then I would argue the election is invalid. So you're going to have to. I don't know if you step outside or you log into someone's Wi-Fi or you do it on like like a cell phone, right? Where you at least have cell reception and somebody can log into the Gmail account or whatever account is utilized. But the obligation is on the association to figure out the technology aspect of it. At the time the vote is called, you should be pressing refresh, right? My guess is you're not going to get a lot of people that do it 2 minutes before. But I would like to be able to say in an election challenge, no, it was 7 p.m. and we watched the property manager press refresh and nothing came up. It would just be helpful for me. So, okay. Annual budget requirements. So we're talking about condominiums and cooperatives. Now, the statute used to previously provide, right? And this is for SERS and non-SERS, right? So it doesn't matter if you're high rise or a low rise, right? That you had to reserve for roofs, paint, and pavement, plus any other deferred maintenance item that is over $10,000 in ultimate replacement cost. That has now been raised to $25,000, which I think is very helpful for a lot of our clients because we were reserving for pool chairs, right? And umbrellas. And I mean, our reserve study was 45 pages because you had all this stuff. So it's now raised to 25,000 and there's now an inflation component to it. So every year the division is supposed to come out and make an adjustment to that prospectively. So if inflation is 3%, then theoretically, January 1st of 2027, the division would come out and say, we're making an adjustment up 3% over the $25,000. It's posted right on their website. It's not usually hard to find, but understand that that is now going to be, and I think correctly so, a moving target so it keeps up with the times. But for this year, it's going to be $25,000. So for a lot of clients, right, you need to take a look at your reserve study and take into consideration this movement and what must be included in your reserves. I'm not saying that you go out and pay for a new reserve study tomorrow, but take it into consideration. But certainly as you do your new reserve study is make sure it's compliant with the statute. A lot of items will now not have to be reserved for. But the big stuff, concrete restoration, railings, right? The general stuff that, fails, pools, stuff like that. but it is a higher threshold. So be aware of that. And that it's going to be a moving target. So every year when the management company's putting together the budget, right, we're going to go to the division website, check. Okay, it's 27,200 this year. That's our new number. That's our new threshold. Okay. Now, an association may vote to waive reserves when terminating a condominium. I have yet, knock on wood, to have any condominiums terminate, right? Where the Ritz-Carlton wants to come in and buy your 50-year-old condo, right, and put a new place on the beach. I haven't had that yet. But if you're running into a situation where you're running into a termination, again, you should be in contact with legal counsel and you should be aware of this. Now, if an association is required to have the structural integrity reserve study, cooperative, 3 stories or more, or a condominium, reserve funds can come from regular assessments. So that would be an increase in your periodic assessments, a special assessment, lines of credit, and loans. This is important because there was some ambiguity. Could we go out and get a loan, go get $1 million loan, and then pay that off over 10 years to meet our funding requirements under the structural integrity reserve study? Or what we've had most clients do is, can we go get a line of credit, right? So there's some nominal cost per year to keep that line of credit open. But if we go get $1 million line of credit, that means that we don't have to special assess the members or catch up on these reserves because we have something we can tap into with you, right? That is now recognized by statute as an available remedy. The idea here is associations that were required to do the milestone inspection and SIRS got killed with the recent deadlines. I mean, you saw the special assessments. It's been on the news because here was the problem, right? If you were a somewhat older condominium, you went and did the milestone. And the milestone said, we found some issues and you require phase 2, and now you got to go spend $1 million to do some concrete restoration or do a new roof or something, right? Oh, in addition, at the exact same time we have to come up with $1 million, you now have to fully fund these 11 categories, right? And ensure all the funding's in place and you can't waive it. So it was like a double whammy for a lot of our condominium clients. And I don't have any cooperatives of 2 or 3 stories or more, but for condominium clients. And so this is this provision and the following slides, a little bit of reprieve, right? That, it's not all required to be done at once. For those clients that have levied the assessments, continue to collect. You're going to be in good shape. The Band-Aid has been pulled. But for those that are still trying to figure out what do we do without forcing many of our members, a lot who are on fixed incomes, to sell, to be foreclosed upon, what do we do? There's now a little bit of reprieve in the statute. There's some new deadlines that reset some things. But one of the things is that you can now utilize a line of credit or a loan to meet the SIRS requirements for funding. Okay. Now, so the special assessment or line of credit or loan must be approved by a majority of the total voting interest. So if you're going to implement one of those options, you have to go out and get a membership vote. Now, that's one of those easy ones. Usually it's hard, like, oh, we got to get the members to participate. Hey, your assessments are going to be cheaper if we can get this line of credit, right? Your participation will be through the roof, right? So that's your sales pitch. I wouldn't say that on the notice, but maybe in some e-blasts is, if we do this, your assessments are this, and if we don't do this, a special assessment or our periodic assessments will go up 40%. Which one do you want, right? You'll get the vote, right? But understand that it does require a membership vote if you're going to utilize those. We've had a lot of clients use the line of credit. Again, $1,000 or $2,000 a year. They're not tapping into it, at least not yet, thankfully, right? And so the renewal every year is not hard because it's not a re-underwritten, right? They just take a look at the financials, say you're in the same position, good. But it satisfies the statutory requirements, right? And obviously, what's the purpose of all this, right? The SIRS is there to ensure that there is adequate funding in place so we never run into another Champlain Towers, right? There's a lot of issues that went on that resulted in that terrible loss of life, right? But one of the issues was that the association simply couldn't come up with the money because they had kicked the can down the road too long, right? Now there's some flexibility, but again, the goal is to get us to a position where we are fully funded and can always undertake the necessary maintenance to maintain the infrastructure, never putting any lives in danger in our communities. All right, another big change, substitute budgets. So I think everybody is familiar, we'll kind of walk you through it, the 115% rule, okay? And now we're only living in condominium world, right? It used to be that if the board proposed a budget that exceeded 115% more than the prior year's budget, the members had the right to petition the board and get a substitute budget in place. Essentially, I know I elected you, but I don't think you're doing a great job and it's become really expensive to live here. I want to put my own budget into place. But it was a member burden to get that in place. That has now shifted to the board of directors. And so this is a new obligation that you will have. So let's go over what goes into the 115% rule, right? So when you look at year over year, when do we exceed the threshold? We do not count required, it's important, required reserves for replacement of the condominium. So that would be paint, pavement, paving, and anything over $25,000, right? So we don't include that, right? We don't include any of the reserves required for structural integrity reserve study, those 11 categories under subsection G of 718, 112, 2G, right? We don't include those, right? And we don't include insurance premiums. So for a lot of clients, those three categories were the only reason we were going over 115%, right? So one, because those are now expressly excluded from whether we're year over year of 115%, likely I don't think a lot of clients will now exceed this threshold. But let's assume you do. It used to be that the board could show up at the board meeting and say, yeah, we're over the 115%. We adopt the budget, and the members had so many days to challenge that, essentially, by proposing a substitute budget. Now it's the board's obligation. So if you exceed the 115% year over year, despite those exclusions, right, the board, not the members, must propose a substitute budget that does not include any discretionary expenditures that are not required to be in the budget, right? So if we're over the 115%, the board can say, that's budget A. This is the one we think we want because it keeps our place looking great. But the board is now required to send out or essentially create budget B that gets rid of all discretionary expenditures. Well, what's that, right? That's the attorney, right? Kick him out. That's a good way to save money right there. No, I'm joking, right? But maybe a little bit lower on the budget, right? But like, for example, if the carpet in the entry foyer, right, is looking a little ratty, but it's fine. But like, we'd like to look better. Or get a new board in there and they're an interior designer and they just want to redo the place. Those are all discretionary, right? Those are not required to be done this year. They're not part of reserves, assuming that the recarpeting or redesign would be under $25,000. So but the board is required to put that in. I do want to make clear, and this is areas where I hope the division steps in, there's no definition of what a discretionary expenditure is. I give you an example of the carpeting. I give you the example of repainting one of the, the pool room or the gym or whatever it may be and buying some new equipment. But there's no definition, right? So you got to get with legal counsel. If we put ourselves in a situation where we're over 115%, less those exclusions, right? But we should be able to work through that, okay? So board sends out budget A, fully funded, right? This is what we want. The board prepares budget B, right? That gets rid of all the discretionary expenditures. Both get sent to the members at least 14 days advance of the board budget meeting, right? Where they're going to be considered. Okay. The notice that's sent to members is for the board budget meeting, and you have to schedule a membership meeting, right? Because members can't vote at board budget meetings. They can't vote at any board meeting. So because the board is required to send out the substitute budget and allow the members to consider that substitute budget, that inherently, at least in my interpretation, means that that board meeting notice is a board meeting and a unit owner meeting to be held contemporaneously. You see my note in there. I think that just makes sense. Okay. So let's walk through how this plays out. We're over the 115%, right? We've done our best, right? But we're at 117 or 118, not including those things. Board prepares budget A, budget B. We send the notice to members of the board budget meeting and the membership meeting. That night, we open the board budget meeting. We introduce everybody, we establish quorum, and we immediately adjourn the board budget meeting. We then convene the membership meeting, and the members get to vote, right, on budget B or the substitute budget. Here's the trick. You have to get 50% of the total voting interest to say yes to budget B. That is a really high threshold, right? It's not 50%, at a meeting at which a quorum is established, it's 50% of the total. 100 units, 51 people have to vote yes to be. You have to get them to show up, and you have to get them to vote yes, right? That's kind of a high threshold, right? So I don't see that, even though the board is required to notice the member meeting and prepare this discretionary budget, I still don't see it as practically resulting in a lot of substitute budgets being adopted. But there's a shift in who's responsible for doing that now onto the board. So what's the walk away from all this, right? Is stay under 115%, right? You don't have to worry about any of it, right? Go ahead.
So play it out. So you convened the
Yep.
budget meeting, you opened up the member meeting,
Mhm.
you've now presented it for a vote,
Yep,
and you don't have 51.
correct. Then
happens then?
budget B fails. You note the member meeting, you conclude it, you reopen the board budget meeting, and the board could adopt budget A.
Okay.
Right? And so that's really the purpose, is it creates this ability at the board budget meeting to have a contemporaneously held unit owner meeting. And if there's enough people that really, really care, they can force the board to do budget B. But at the end of the day, it's still a bunch of hurdles, and membership participation is hard, right? So I don't see it practically resulting in a lot. But look, if you're over 115%, right, get on the phone with legal counsel, probably have legal counsel there and have them just run you guys through it, or at least before the meeting, get management and the board on the phone with legal counsel and say, here's how you run it, ... And you just walk through what the scenarios are. But you're exactly right, is if it passes, right, then the board is going to adopt budget B.
Is there any science behind having the budget meeting open and then immediately adjourn versus just opening the member meeting initially?
No,
And then-
I just contemplated that the board
You're
is
not doing-
considering the budgets.
You're not
Right.
doing anything with the budget
Correct.
meeting initially,
Correct.
you're opening the meeting and then closing it,
Correct.
adjourning it.
Correct. Well, I'm establishing quorum and proof of notice, right? Because that then
Okay.
allows me.
Okay, gotcha.
gonna do it.
That's the
Correct.
problem. Okay,
Correct.
gotcha.
Exactly. Yes, there's a question in the back. Right. So the question, and I'm just doing this for the people online, is what if there are items on the budget that exceeds 115% that the board considers safety items? So those, in my opinion, are not discretionary. But it's kind of one of those, you know it when you see it, right? So if we're going to be over 115%, right, I think you really need to be talking to legal counsel about, well, what do we view as discretionary? And here's the good news is is number one, you're shifting the liability for that decision to legal counsel, right? Which creates a defense for the management company and the board of directors that relied on the advice of legal counsel. But number two is there's no definition, so I'm just gonna have to figure it out, right? Make it my problem, not your problem, right? But the point being is, if the division comes up with guidance on this about what is discretionary versus what is safety, it would be very, very helpful. They are very overwhelmed with all the investigative work they do, right? All of these statutory changes, which again were to 718 and 719, which is what they have jurisdiction over, that it's not going to happen before annual meeting season, certainly not before this year's budget season, right? And so it's kind of that if we run into the issue, we're over the threshold, we should be talking to legal counsel and looking at all the options, and we'll just outline for you what options we think, where's the risk, where's not the risk, and try to be, frankly, as transparent with the members as possible, right? As to how the board with the decision-making process. Good question. Yeah.
Well, here you go.
Yep.
115% budget, you have $100,000 budget. That's 215,000 or 115,000?
Oh, it's 15% over. Yeah. It's the 100.
It comes to 16, you're over from last year. So you had 100,000.
Yeah, if you had $100,000 budget in excluding required reserves, SERS, and insurance premiums, if you're now at 116,000 for the new year, then this rule comes into play. Yep, no problem. Okay, and again, no changes to the cooperative statute. So just be aware, this is condominiums only. The cooperative statute does have a 115% rule, but that remains the old way, where it's up to the members to come into play there. Okay. Now, for those high-rise, or I guess habitable buildings of 3 stories or more, you have some reprieve on SERS, right? No real changes to the milestone inspection requirements, but you have a little bit of reprieve on reserves. So you now have that for a budget adopted on or before December 31st of 2028, associations that have done their milestone inspection in the past 2 years can pause reserve contributions for up to 2 consecutive budgetary years. And that's the double whammy I was talking about, where if we're levying $1 million assessment to undertake what is a phase 2 of a milestone and trying to catch up on reserves, which we punted down the road, right? The assessments are through the roof, right? And so what the statute says is, look, if you've done your milestone and if you're undertaking work, you can defer the implementation of subsection 712(2)G, which are those required SERS, right? Reserve contributions. Now, is that a good idea? Not necessarily, right? Is there a middle ground, right, where you put some away? I'd probably recommend it. But again, it's a balancing of ensuring that what you're implementing is sustainable and can be tolerated by your membership, right? Versus catching up as much as you possibly can so that when we do get to, I guess, the 2029 budget would be adopted in 2028, right? Unless we want to start adopting these like the first of the year. So really 2029 is when you have to worry about. Now, who qualifies for this? It's only a limited subset of our condominium clients, right? So one, you got to be 3 habitable stories or more. So I'm thinking the beach, usually, right? That's where you go to see the high rises, right? Number 2, you have to get the membership approval to hit the pause button. Okay. Now, that shouldn't be hard because if you go to your members and say, would you like to not have to pay as much in assessments for the next 2 years? Most of them will say yes, but it is a majority of the total membership interest has to approve the pause. So we have to have a membership meeting and we have 100 units, 51 people to vote yes. If you do that, you can pause for up to 2 years. If you're developer controlled, you cannot do this. If you have bulk buyers, meaning you have a majority of the units owned by some entity that's not the developer, you can't do this. But for most of our unit owner controlled associations, it is an option that exists. Now, some other caveats to this. Let's assume you've done your milestone inspection. Let's assume you get the membership vote and you do decide to press pause, either in its totality or not fully funding what the SERS requires. Before you start again, you're going to have your SERS updated, right? Or go ahead and get a new one, right? Because obviously details have changed on useful life, cost of stuff. So if a SERS costs you $10,000, we're going to incur that again because we hit pause. So understand that there is a back-end cost to all of this. The purpose of this, again, was to avoid the association being hit on 2 fronts and find some middle ground where assessments are going to go up, but not as much as what was originally contemplated in Senate Bill 4D back in 2022.
So how that would work, if I understand it, is we would pay up till 2028, and then at 2028 we would go on pause, or can we pause now until?
If you go get a membership now, you can hit pause, right? If you've done a milestone inspection in the past 2 years and you get the membership vote and you know that you're going to have to go get a new SERS at the time you start implementing, but no later than the 2029 budget are you going to have to now be where you should have been as of prior to the statute. Okay. Reserve funding methodology. So there's 2 lines or two methods, right? There's the straight line method, the buckets, everybody the roof bucket, the pavement bucket, right? And a lot of clients have moved to pool, right? Which is 1 bucket. So if something fails early, we can reach into the entirety of all the reserves, right? To use the cash to get the problem taken care of, right? It used to require a majority vote at a meeting at which a membership quorum is established to switch from straight line to pooled or pooled to straight line. That is now a board vote. Okay. So the board has been given real flexibility to make that change. And so you are now 1, statutorily permitted to pool reserves, and the board can implement that. Caveat: you cannot pool, if you're a 3 stories or more of habitable units, SERS reserves, subsection 2G, those 11 categories or 9 categories, in non-SERS required stuff, right? So if you're putting away, because you're a high-rise condominium, for the roof, the painting, the foundational elements, whatever may be required, fireproofing and all those items, you can't mix that in with the pool resurfacing, right? You can have two pools, right? But you cannot intermingle them. So just be aware of that. Now, can they be in the same bank account? Yes, right? Or the same investment account? Yes. But from an accounting perspective, you have to have them on two different balance sheets. If that makes sense.
This only applies to condo associations, but not HOAs.
Correct.
They would still require membership.
Correct.
of it.
Correct. It's a quorum. You establish a quorum, and then a majority of those have to vote in favor of it. Correct. But remember, an HOA too, that's only if there's mandatory reserves, right? So most HOAs have voluntary reserves, which means the board's in complete control of everything. But if you do have it in your governing documents, or the memberships have voted to implement HOA mandatory reserves, then a membership vote would be required to switch the funding methods. Good question.
So as long as the accounting on
Correct.
paper is clear.
Correct.
You can have everything in the same checking account.
Correct. Exactly. Okay.
John?
Yep. Yes.
If a board wants to condense the reserves, like say they have 6 AC reserve funding.
Yep.
And they want to condense it to 1, can that be a board vote, or does that have to be a membership?
All right, so it can be a board vote. So the determination of what reserves has been shifted from members have some input to now the board has full discretion as to the funding methodology, right? The only restriction now is SERS reserves and non-SERS reserves, right? But if the board says we want to put everything in pooled and keep these two separate on paper segregated accounts, completely within the board's discretion, the membership no longer has the ability to come in and dictate that. Or realistically, the membership vote was a hurdle for the board. And most of our clients have shifted to the pooled reserves because frankly, it just affords more flexibility.
So theoretically, a board can go in, make a vote here at their next meeting in October, November, to go to pool.
Yep.
And all of the 6 buckets in the SERS components and the 5 buckets in the non-SERS, instead of having 11 line items on the balance sheet, in the November financials will be 2 buckets.
Correct.
SERS, pooled, non-SERS pooled, and whatever total number that is.
Correct. So long as there is a baseline funding formula of how the pooled reserves are calculated,
Yeah.
right? Because there's,
Yes.
I mean, it has to balance,
You
right?
still have to have some sort
Correct.
of logic behind the
Correct.
the SERS component.
Correct, exactly. But from a monthly cash flow statement or balance sheet, the answer is yes. If
I
the
have
board,
several COAs that have maintained those individual separate buckets, and they also have now a pool bucket.
yeah,
So
Yeah.
now they can actually take action to consolidate.
correct.
Okay,
Correct. Yep, absolutely. It make sure the meeting minutes reflect the board vote, right?
absolutely.
For your sake and everybody else. So okay. So that was a big change. Okay. Now I'm going to focus a little bit on just structural integrity reserve study, right? So this is just going to be condominiums of 3 stories or more that are habitable. Okay. So there's always been this question about 3 stories or more, and what does that mean? There are a lot of clients who the first level is like a garage, right? Because they're trying to meet the flood elevation requirements. And then there's levels 2 and 3. They've now clarified that you don't count that first level, right? So it's 3 habitable levels that apply. Obviously, for the high-rise condominiums, you've always known, right, on the beach. But there were some clients who had this kind of maybe we are, maybe we aren't, and the statute is now clarified that it's 3 habitable stories. Okay. Now, any design professional or contractor that is performing a structural integrity reserve study for an association must disclose in writing if they intend to bid on the maintenance or repairs. Let me give you the context. There were many companies, contractors that came in that were performing the SERS and determining what work had to be done and then bidding on the work itself, right? So if I was going to say, well, you got to spend $1 million and I want the contract for that, that seems to be a little bit of a conflict, right? So you could still do it and it still make very good logical sense because it's a reputable vendor and we like them, but they have to disclose to you in writing if they intend to do it. And if they fail to disclose, they cannot be considered for actually performing the work that's underdone. Again, not something that usually happens in the Treasure Coast, but like you get into Miami-Dade, Broward County, right? You can run into some issues where there are fly-by-night contractors who were, because the association couldn't find anybody, right? Well, this guy has a website and it says he's a reserve specialist, but he's also a concrete contractor, right? And so they were building up the SERS as high as could be, knowing that they were going to get the work on the back end. Disclosure is now required. Okay. Yeah.
Put it out to bid. If they can fund this fund.
You would still go ahead and put it out to bid. So correct. So you're still, the competitive bidding requirement's still going to exist, right? But a known contractor who has performed well that did your SERS may be more likely to be awarded an ultimate contract because the board's familiar with the guy, right? Has seen their work product versus somebody coming in that is unrelated to the project bidding. Maybe we don't have the familiarity to it. So they had their foot in the door, right? And so if they have their foot in the door, they should be required to disclose it, but you're still going to do the competitive bidding requirement if it exceeds the threshold. If they fail to disclose, the contract is voidable and they can be disciplined, right? So design professionals and contractors have to be registered with the DBPR. So they now have enforcement rights to say, not only does the association can get out of the contract, but in addition, we're going to take disciplinary action if this does occur. So just something to look out for. It's a conversation that if you're engaging a firm to perform the SERS, probably need to have a conversation with them. I can see situations where you have reserve associates or reserve specialists, these companies, literally all they do is reserves, right? That they're not contractors, right? They can't perform the work. But in the instance where you have a engineering firm that's going to come in and do your SERS and then oversee the work at the end of the day, that needs to be disclosed in writing to the association. Okay. Updates as to reserve funding. So I'm going to read this and then we're going to talk about it a little bit. Baseline funding plan, right? The structural integrity reserve study must require a recommendation to keep the baseline funding plan cash balance above zero, ensuring financial stability. In addition, it can recommend other types. What does that mean? Your reserve schedule under your structural integrity reserve study can't contemplate that in 2027 we have no money in the account. It's like, duh, right? I mean, it's not, I don't know who would do that, but apparently there were some people out there that were saying, yeah, you're going to be in a negative position at some point in time on this timeline. Not appropriate, right? You always need to have at least $1 in the bank. And that's kind of what the statute now affirmed. I don't know who would accept anything other than that, but it's in the statute. Again, you can do it through assessments, loans, lines of credit to maintain, right, and satisfy the requirements. If performed before the association has approved a special assessment or line of credit, it has to be updated to contemplate that. So what that means is, let's assume last year we went out and got a structural integrity reserve study, okay? It comes out, oh my gosh, it's a lot of money, right? Well, if we go out and get a line of credit, or we go out and get a loan, or we levy a special assessment, that's going to impact the funding either we have in the bank, if you do a special assessment or a loan, or the line of credit money we could tap into. All that's saying is you have to update the reserve study to reflect that this money is now available in our bank account or available via line of credit. If the association obtains a milestone inspection, it can delay the performance of the structural integrity reserve study for up to 2 years. That's the one we talked about earlier. And new requirement for my board members in the room. When you become a board member, or if you're an existing board member, you have to sign an affidavit that you've received the structural integrity reserve study. Apparently, there were some instances where the association had it, it was in a box somewhere, and board members had never seen it. Managers, you need to get that in the hands of the board members, and they need to sign an affidavit that they got it, right? So I'm assuming Vesta will come up with some form. Certainly, our office can help you prepare a form for the board members to sign, but that's part of the official records, and it's something that, as busy as you volunteer board members are, right, could be easily missed. So please just pay attention to that. Make sure it's satisfied. Once you get it, check the box and move on. Correct. Okay, let's talk about hurricane protection. So last year, there was a tweak to the statute that said that if the association is going to undertake work to the common elements, generally the exterior of the building, balcony repair, which would be common elements, right? And they disturbed a homeowner hurricane protection, hurricane-proof doors, shutters, the accordion shutters, right? That the association had to go ahead and pay for the reinstallation or repair of those items. This shifted, without any exception, a large financial burden on the association. The statute has been amended to contemplate that that's the default position, but if the association adopts an amendment that says, no, 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 it is a unit owner responsibility, that is now permissible. But it has to be in your declaration of covenants or declaration of condominium, excuse me, right? So if your declaration is silent, the statute applies. The association has to take off the accordion shutters to redo the balcony. The association is responsible for putting it back and paying for the cost thereof, unless the amendment exists to the declaration or the declaration itself that says, in that instance, the statute does not apply. The homeowner is responsible to go ahead and do it. So essentially, it created a default position by statute, which is compliant with what was adopted last year, but now there's an exception if you implement that. If that is something the association wants to implement, you adopt an amendment to the declaration, and that will control in this instance. Okay, let's talk about the division in itself and all the scary things it can now do. I'm just kidding. They do a great job. But they got more power, right? So they have now been added, like in section 914 is the criminal section of the Florida statutes that says that investigations of the DBPR are now included in what can be looked at in a criminal investigation, right? So they now have more power. This really comes from board members taking kickbacks, board members writing themselves $1,000 reimbursement for expenses at Home Depot when they only got $500. The DBPR previously had to say, that's a law enforcement issue. We can't look at it. It makes sense they should be able to look at that. It makes sense they should be able to suspend these people from being on the board, right? So it kind of confirmed something that should be there. Associations, excuse me. Make sure I'm not going to run out of battery here. There we go. In cooperative associations must create an account by October 1st of 2025 with the DBPR, right? So management should be directing the board to create that account, and you should maintain that account that has certain basic information about your condominium association. Most importantly, who are the board members and how do we contact them, right? Many of the associations we represent, right, are represented by a management company. So it's not that hard to get in contact with them. But there are some self-managed smaller condominiums where the board members, right, are away most of the year. And there's like one person on site that like basically calls the board member if there's an issue, right? The DBPR is having a little trouble getting in touch with them. So you're now required to register and keep that all up to date. Board member changes, October 1st of 2025. So we have 4 days, right? So if you guys haven't, call me. We'll figure it out. You have 30 days to update if there's a change in board members or a change in management, right? And the idea is that they always have the latest and greatest contact information. I can see scenarios, not like in an annual election, but where the board member has a health problem and steps down and resigns. And we just don't think about, oh, you know, we got to also update the DBPR. So just make sure we're thinking about that as managers and as board members, that if there is a change in who's on the board or there's a change in the management, one of the criteria we always do is we go to the DBPR and we update that. We should also be updating SunBiz, right? Which is the division of corporations, but the DBPR too. So we're just going to add that to the list of things to check off, right? Now, you also have a new requirement that if the division requests information from the association, you are on a clock of 5 business days, right, to respond to them. So if they say, we want to see a copy of your SERS, start the clock. 5 business days, you know, is not a whole lot of time. So managers, if you're a volunteer board member, really need to stay on top. If the division contacts you, we are canceling dinner and we're going to get them what they need, right, to ensure that there's compliance, because that's one of those where there's administrative penalties and investigations that can ensue. And it's, you know, if you want documentation, here it is. It's an official record. You just get it in the hands of the division. And obviously, if you're contacted by the division from some investigative capacity, please call me, right? You know, before they make a decision or before they interview, and we can help you walk you through that. Yeah. No. Yep. So remember, for homeowners associations, the question to the people online is, does this apply to HOAs? The division has very limited jurisdiction over HOAs. Talk to me in 5 years, right? When it's probably becoming more like they're going to at least know who's on the board. But right now, other than recall disputes, right, and election challenges, they really don't mess with HOAs. And so there's no requirement statutorily for HOAs to register with them.
For a board where it's been suspended, it didn't take its continuing education, but it could come on at any day. Do we have to notify them of a suspension after the 90 days?
Correct. Anytime there's a
Even if
change.
they do something?
Correct.
Just having a little bit of technical issues, everyone. Just hang tight for 30 seconds. Welcome back, John. I was about to tell some.
I'm here. I'm here.
I was about to tell some jokes, but let me get this joke out of the way.
Is it stand-up hour?
Why did the HOA hire a magician? To make your patio furniture disappear when it's not approved. All right, you can go back to what you were doing.
I appreciate it. That's a good one. I should have a stand-up routine. So let me go ahead and share my screen. Here we go. Well, the sad part is all we're talking about now is HOAs, which had no statutory updates. So give me 1 second. Okay. Can you see that, Kevin?
Yep, you're good.
Okay. We'll get there. Okay, perfect. Okay. So it's kind of ironic because I'm now on homeowner associations, and the only slide I had was no amendments to Chapter 720, right? So that was the closing joke. But the legislature did consider several items to go ahead and address in the HOA, but it did not pass anything. And rather than talk about what was considered or what may come up, I like to not confuse clients. Essentially, there were no changes to Chapter 720. I do want to talk about one thing that may impact our HOAs and condominiums is dogs, right? Not emotional support animals. No, bad dogs, right? Bad dogs. And so I do want to make all of our clients aware of the Pam Rock Act, who was a mail carrier down, I think in Miami-Dade County. It was a delivery mail attacked by a pack of dogs and unfortunately killed. And so an act was implemented, and in her namesake, that imposed additional requirements for dogs that have bitten people and been designated by a court or by animal control as bad dogs. And so it requires that they be confined and impounded during the investigation by law enforcement or animal control, right? There is and I looked this up last night, there's something called the Dunbar bite scale, right? Which deals with the severity of it, which is something that's weighed by animal control. And owners must proactively confine these dangerous dogs. So if you have a bite in your community, it is very important, one, that the injured party contact animal control, and if the injured party will not, that management contact animal control, make the report. We cannot control what animal control does with that information, but my recommendation is you make the report, fill out an incident report, so there is documentation as to the witnesses, what your understanding of it is, if you observed it, if there's video footage, those type of things that exist, right? And again, can be provided to law enforcement. This act also requires that owners who have a bad dog that have been designated by animal control, that they carry a liability policy of $100,000 in coverage to ensure, right, that future bites, right, that there's protection, and the dog has to be microchipped. And these really help identify bad dogs. If they get loose, right, and animal control picks them up, right, you can microchip them. I'm sorry, you can run the microchip and find out who they are. But also it creates a level of insurance requirement to buffer against liability concerns if the dog were to bite someone else. And so it also creates criminal penalties for owners of bad dogs. It's now a first-degree misdemeanor, right? If you have a bad dog that then causes harm, and especially if you have prior knowledge that the dog is dangerous. And this is not the dog who's allowed in the condominium, right, or in the HOA that barks. It's the one that's aggressive, that's snarly, that has actually injured either people, or most instances we see other dogs in the community. Let's attack them. You need to document, you need to keep track of these dogs, right? And obviously the idea here is to deter and to encourage or alleviate the hurdles that were in the way of enforcing these types of restrictions. So how do we look at it as, I guess I did this for the HOAs, but condominiums and cooperatives too. Know that if we have a bad dog, right, there are now criminal penalties that can come into play. There are insurance requirements that can come into play. A lot of clients have that. You can't conduct unlawful activity in our community, right? Well, if you have a bad dog, you don't have the insurance, you're now engaging in unlawful activity, right? If that dog bites someone, you're engaging in unlawful activity. So it's ways to hook the jurisdiction of the HOA from a covenant violation. I'm not saying that when your tax dollars at work with animal control, we jump in front of that, let them do their job, but it gives us the ability to also participate to the extent the board deems it to be a danger. Correct. And a dangerous dog is a defined term as one that's bitten and determined by animal control or a court of law to be that. So this doesn't change. Every dog gets one free bite. Yeah, correct. But every dog gets one free bite, right? But it's important that the association stay on top of these things. A lot of times we get the incident occurred. The homeowner is, I don't want to deal with it. I just want to go to the doctor and get some ointment for my leg. And it's really on the association to step in, right? And not overtake what the injured party's complaint is, but to put animal control on notice that this occurred, to document that it occurred, so that if this occurs again, right, the association's undertaken reasonable efforts to mitigate the harm or the danger to the residents. Because there's been some cases, I'm sure you guys have seen in the news, where the association knew about a bad dog, did nothing, even though they had a pet restriction. Dog bites someone else, personal injury attorney comes and sues the association. Why? Because they're arguing you're negligent. I disagree, but you have $1 million or $2 million insurance policy. And that's all they want, right? They're doing it for the injured party to make them whole and yada, yada, yada. But understand that you're always going to be a target. And that's why I recommend that you be a little proactive. So, okay. That's all I have. I hope the people in the room learned a bit of something. I do want to thank Vesta Property Management for inviting me back. Feel free to let them know if I did a good job. And if I didn't do a good job, feel free to give me some feedback too. I always want to provide a good report for clients, a good summary of the legislative updates. I will encourage the legislators to move on the HOA Act a little more next year, right? So you guys can get an update. But we're still digesting everything from last year and the board member education requirements, the criminality of certain provisions when you destroy official records, all that stuff. It's still coming into play. What I could see next year, if I had a magic 8-ball, would be the electronic voting provisions that are in the condo statute. I could see that easily be converting the HOA statute, those kind of things. But again, for this year, it's not required, but know that HOAs still have electronic voting. So with that being said, Kevin, I will turn it back over to you. And I have some people in the room. If you all have questions, I'll stick around for another 10 or 15 minutes, and then I'll let you go about your day.
Good job, John.
Thank you.
Thank you.
So Kevin, do you want to go ahead and I don't know if I can see the chat. Let me see here. Maybe I can see the chat.
Yeah, the Q&A.
Yes.
And I will let everybody know, since they're asking, yes, the webinar and presentation will be live on our website. And everyone that attended will receive an email with the links and information by the end of the day, if not tomorrow.
Thank you. Thank you. And again, once we get the certification from the DBPR, they're busy people, but we are politely reminding them this is outstanding. We will forward that to Vesta and get the certificates issued. And take that, put it in your file, get a copy to the management company. Okay. So Kevin, I see 4 questions and answers. Is it okay if I just read them?
100%.
Okay. So an anonymous attendee, well, there we go. Can they investigate if the president hasn't been active at board meetings for a year's time? So no, the DBPR would not have jurisdiction over that. And likely that would not be something that would preclude a board member from being disqualified from their position. Board members get to be on the board until they're voted out, until they resign, or until they die. Hopefully not the last one, right? But you're kind of stuck with them until that point. So thank you for that. Somebody said, can they get a copy of the presentation? Absolutely. Kevin answered that. Somebody said, great job. Thank you. Thank you. Is it Curtis? I really appreciate that. So, and the last one says, please consider starting with HOA next time. Okay, we'll do that. And there was a question about, when talking about common elements, you said if we wanted to change it in our bylaws, we could do it. Does it require a majority or 2/3? So that's going to be a document-specific question. I'm assuming that your question pertains to the obligation to pay for the cost and reinstallation of hurricane protection when the association is undertaking work to the common elements. And so it's an amendment to the declaration of condominium that's required. And you're going to look at the amendment section of your declaration. Usually it's at the end. And in that, it will provide an amendment is X number of vote. Sometimes it's 50%, sometimes it's 2/3. Sometimes it's 75%. Sometimes it's a majority at a meeting, which a quorum is present, but it's going to be document specific to go and get there. Next one. Do you have an owner vote to special assess for painting a building now that it's part of SERS? So under the statutory amendments, it states that if you're levying a special assessment to fund the SERS, through a special assessment, line of credit, or loan, you do have to go and get a membership vote. I think that's different than if we need to undertake the project today, right? And we need to get funding in hand to go ahead and undertake that. So if we're putting money away for later, I think the statute applies. If we're undertaking the project now and there's a shortfall in capital or cash to get it done, I still think that we look to the association's governing documents to determine special assessment authority, whether it's the board or a membership vote. And I think that is the end of the questions. So I appreciate it. Before I excuse the people online, are there anybody in the crowd that has any questions? Sure, please go ahead, Chris. So good questions. The question is what is the continuing education requirements? So now that everybody's taking their board certification, it's not by the end of the year. The statute was adopted July 1st, so it's going to be June 30th of 2026, which weird saying that we're that far, but that's the cycle. every year because of when the statute came into effect. And so what you're going to go ahead and do is it's going to be 4 hours, right? And if you're HOA over 2,500 units, I believe it's eight-hour requirement. So attend seminars like these. I know you guys probably put on a couple a year. I watch them, right? I like to see what other attorneys are opining to and making sure that I'm at least giving consistent advice with everybody else in the field. But I know you guys have, other than attorneys, other people come in and other law firms make presentations, other management companies make presentations, not as good as this one, right? But really shouldn't be hard to go ahead and sign up and get educated, especially it's 4 hours a year, right? We've put in for this one requesting an allocation of 2 hours. So assuming we get the thumbs up from the division, we're halfway there for most of our clients. All right.
I don't know which things they can take. Tell your board members something on clearly say disqualified, or they can
No.
water basket weaving for no reason.
Well, underwater basket weaving is not part of the statute, so that one may not be, right? But basically you have to take a course approved by the division, right? And so as providers, what we do is we prepare the course, we submit to the division, when they give us the blessing, right, provides a certificate of approval, and that's what utilized to go ahead and provide. In this case, it's with the division. We're just waiting the feedback to ensure it's really about, are we going to get 2 hours of it? I think today we're at about 2 hours, so I think it's appropriate. Right. All right.
Hey, John.
Thank you so much to everyone online. Kevin, go ahead.
3 last questions, John.
Sure.
Do you mind? I'll just read them to you. Can a condo unit owner force a board to address a legitimate financial question?
Yes. So the question is, is it a board member or a unit owner?
Can a condo unit owner force a board to address a
Can a
legitimate financial
condominium
question?
unit owner require the board to address, right, a financial issue or financial question? And so the answer is yes. So the way that most homeowners have a requirement that the association undertake something is you start with what's called a certified written inquiry, right? Which is a letter to the board sent certified mail, right, or to the association's official address. And they have 30 days to respond to that. Or if they refer to legal counsel, right, then they have up to 60 days to respond to that. If the association does not respond, it opens potential DBPR investigation, right? But most importantly, if the litigation ensues after that, it bars the association from recovering its legal fees. So much like records requests, when we get those in, we acknowledge that we got it and we start the clock and we make sure we hit those deadlines. And that's how I would go and get information from the board on a financial question. And then certainly I would encourage that member show up at board meetings, right? Be polite, be professional, right? That's it. Sometimes it is, right? But I've found you get, is it more with honey and less with vinegar, right? Is, even if you're challenging the board, if you do it in a way that you're asking it in a polite way and getting other members to say, I also want to know the answer to that, right? A board should engage in good faith and try to get those answers. And a lot of times at a board meeting, the board doesn't know right then, right? And so what I encourage a lot of clients to do is if you don't know the answer, don't guess, never do that, right? Especially if it's video recorded, right? But say, you know what, that's a really good question, right? I'm taking my notes, or could you get that to me in an email? And then we'll get back to you, or we'll take it up at a future board meeting. And I would encourage the boards to engage in that way. That does not mean the person that shows up with every board meeting with a manifesto, right, that they get to control everything. You get 3 minutes as to each agenda item. But if somebody's operating in good faith, and I would hope the participant is operating in good faith, that's the way I would approach that. So thank you. All right. I appreciate everyone's time. Best of luck in the rest of the week and getting us to, it's Thursday, right? One more day till Friday or till Saturday. So thank goodness and be well, everyone.